Thank you, Kathy, and good afternoon, everyone. So I suppose today I should do an introduction. This is my first week hosting the webinar. I want to thank Adam Mastroleo for his work over the past year or two as the biweekly host. If you look at my wall behind me, he's actually on the other side of that wall. So we just moved over one office. So anyway, happy to be here with you today as the moderator. We have 4 excellent presenters for you today, and I'll quickly go over what our agenda looks like. So first we'll have John Godso from our Buffalo office, who's an employee benefits attorney, speaking about environmental, social, and governance investing with employee benefit plans. And we'll then move on to Suba Viswanathan, who will talk about compensability of travel time, a very common question that we get here as labor attorneys. Next, Jackson Soames from our Rochester office will talk about an interesting Supreme Court decision that came down just last week about students and disability litigation in federal court. And finally, we have a very, very timely topic given the recent news in banking and bank failures. Dory Bailey, one of our banking attorneys, to talk about this issue and the basics of FDIC insurance. So with that, we'll turn it over to John over in Buffalo for his presentation.
Thanks so much, Kristen. Good afternoon, everyone. Happy to be here today. And Kristen, you're off to a good start on the first day. I'm sure you'll be a great moderator for us in the upcoming months. So today we're going to start our program with a discussion about ERISA, employee benefits, and fiduciary responsibilities in connection with ESG. So if we can go to the next slide, please. So what is ESG? It's a terminology that some of you may have heard before, others perhaps not. It's a term that's basically commonly used to describe environmental, social, and governance factors that can be used to evaluate a company or an investment's sustainability. So for example, some examples from an environmental perspective might be looking at the carbon emissions with respect to a particular company. Social factors may be human rights record, for example, and their operations overseas. Governance factors may include diversity of board members. So these factors are elements that may be considered by fiduciaries in connection with making decisions on investments in an ERISA lineup of a covered retirement plan. For example, your 401k plan, 403b plan. So my suspicion is for those out there who are involved in decision making with respect to your retirement plan, if you're involved with a retirement plan committee, you've either never given ESG a thought in connection with those decisions. For example, you may have an investment advisor who talks about various mutual funds that may be offered under the plan, and the topic of ESG really never comes up at all. You evaluate these investments at quarterly meetings, you look what's performing well, maybe something has a watch list, but ESG isn't really part of your conversations. Some of you may be already in the process of considering ESG factors and making those decisions. For example, if they align with your organizational goals. I think for either group, this presentation will be helpful. Some of you may be wondering if you've heard about some of the news regarding ESG. If you're in the group that has never really thought about ESG at all in connection with retirement plan decisions, do I need to do that now? Does ESG have to be, or is it supposed to be part of my fiduciary decision-making process when I'm setting my fund lineup within my 401k plan, 403b plan? A preview to that answer is no. But you may be wondering that as a result of some of the things you may have heard in the news or otherwise. If you're in the other camp and have used ESG considerations in connection with your fund lineup, you may be wondering, okay, as a result of recent guidance, has the door opened wider to reduce the litigation risk, perhaps, if I make ESG considerations more of a component of the selections within my investment lineup? And I would say, and we'll talk about that in a moment, the door maybe is open slightly, but perhaps not as much as you may think or may have read in the papers regarding the recent guidance and recent actions taken by the Biden administration. So we can go to the next slide, please. So ESG in the news. Recently, President Biden exercised his first veto ever with respect to a bill that sought to void a 2020 DOL rule, and we'll talk about that DOL rule in a second, that would allow retirement plan fiduciaries basically greater flexibility to consider the financial benefits of investing funds that consider climate change and other ESG factors. So that was recently, I think March 20, 2023, recent event. Other recent events include a 25 state coalition suing the United States Department of Labor in Texas, and these are mostly Republican-led states, seeking to overturn this 2022 DOL rule, which we'll informally call the Biden rule here, and we'll talk about that in a second. So we have states looking to sue the DOL to overturn the rule regarding ESG. We have a bill being proposed in Congress that President Biden recently vetoed that also tried to overturn this DOL 2020 rule. And along with that, we have numerous states passing laws prohibiting the use of ESG factors in investment-related decisions with respect to their own state-run plans. So there's a lot of consideration, a lot of talk, both on the national level, on the state level, as to how prominent or whether or not we can use ESG factors in determining what the various investments are in connection with our retirement plan. So if we go to the next slide, please. So I've talked about the 2022 DOL rule, and that's what's caused these litigation, caused the veto, or resulted in President Biden's veto. So what was the 2022 DOL rule? But first, if we step back for a second, there was a 2020 DOL rule issued under President Trump. So this 2022 rule supersedes the 2020 DOL rule. That 2020 rule generally required fiduciaries to select investments based solely on quote unquote pecuniary factors. And it also, among other things, prohibited the QDIA, which is a qualified default investment alternative, basically the default fund in a retirement plan if a participant doesn't make elections. And typically a QDIA holds a lot of plan assets for those participants who are just in a state of inertia and don't want to make a choice among the various investment options under the plan. But this 2020 rule prohibited the QDIA to include a non-pecuniary objective. When the Biden administration came in and evaluated the effect of the 2020 rule, it said what it thought was produced was a chilling effect on the ability of fiduciaries to at least consider ESG factors. So the 2022 DOL rule says, among other things, that the risk return analysis that a fiduciary should be undertaking to consider whether a particular investment is prudent and should be included in an investment lineup may include ESG factors. And it's important to note that this necessarily isn't a change from prior law. Even under the Trump rule, ESG factors could be considered, but it had to be part of the overall financial analysis of whether that investment was appropriate in the lineup, whether it furthered the interests of participants and beneficiaries in the plan. Because if you recall, one of the core fiduciary obligations of a retirement plan fiduciary under ERISA is to act solely in the interests of participants and beneficiaries. So this idea of having some kind of collateral objective, even if it's in line with perhaps a company or organization objective, is inconsistent with the idea of how we should be investing our or how we should be setting our investment lineup under an ERISA plan. The 2022 DOL rule also removed this pecuniary factors language, which was under the 2020 Trump rule. I think primarily when you look at the actual change that occurred by taking out that pecuniary factor language, wasn't a lot. Under both rules, you still have to consider the risk and return that may be achieved by considering the ESG factors. But the pecuniary factor language, I think, led many to believe that, okay, it's only money. We can't think about ESG factors at all, even if they may affect the risk and return analysis. It added language that arguably provides fiduciaries with greater flexibility under the quote unquote tiebreaker rule. And I'll talk about that, explain that here. The tiebreaker rule has been something around since 1994. It basically says, well, if two investments are basically the same, you can use collateral interest or a collateral type of benefit to determine whether one should be put in the lineup versus the other. Under the Trump rule, it basically said the two funds must be economically indistinguishable in order to go to this tiebreaker rule. The new rule went away from this economically indistinguishable language and provides fiduciaries a little bit more latitude in determining whether there actually is a tie between those two and whether now we can move into considering ESG or other collateral benefits from a fund. The new rule also eliminated the QDIA prohibition. In other words, you can have a QDIA that has a goal of promoting a collateral benefit like ESG, but you still need to be looking at risk and return factors. You can't substitute having that collateral goal if you know you're going to have less of a financial returns in connection with that substitution. So that risk return analysis maintains being part of that core analysis for plan fiduciaries. And it also clarified that participant preferences may be considered. And again, this is more in a tiebreaker situation. If you have an organization where participants would prefer a investment that has some type of ESG element to it, all things else being equal, and you know that might promote additional investment in the plan, additional investment returns in the plan, then that can be considered by a plan fiduciary when setting up the core lineup. So those were the main changes in the 2022 DOL rule. But the important factor here is that risk return analysis maintains part of the fiduciary obligation of the plan fiduciary when they're considering whether an ESG factor related investment can come into the lineup. If we go to the final slide, please. Okay, so what are some of the practical considerations here? As I just mentioned, the rule really continues to be the same as far as a plan fiduciary can consider ESG factors as part of the risk return analysis. Be wary of this kind of Trump rule versus Biden rule mentality. In other words, thinking, okay, the new Biden rule really promotes ESG in a way that the Trump rule did not. Both really provided for the fact that you had to consider the economics that ESG analysis provides with respect to that particular fund in the fiduciary's consideration. Really, we want to go back to our fiduciary process that should be part of the selection of any retirement fund. Look at your investment policy statement, memorialize your investment decisions, and go through a prudent process. So analyze each individual investment option that's in the plan. And if you're going to put a fund that has some kind of ESG type factors related to it, go through the analysis of whether you believe that adds to the potential return of that fund within the investment lineup that's provided under the plan, and document it. At the end of the day, to avoid those litigation risks, we want to ask ourselves, why are we putting this fund in here? Are we just putting it in because we think we agree with the social causes that this fund might be promoting as a result of its investments? Or are we putting it in here that, yes, it does promote those types of social causes, but it also has a risk return analysis that will benefit participants financially at the end of the day? So I think takeaways here are: continue with your fiduciary process. Don't think about this as a Biden rule versus Trump rule. Think about it, okay, ESG may be one of many factors that I should consider as a fiduciary when I'm setting my investment lineup, and I should go through my fiduciary process just as I always have. So that, Kristen, I'll pass it on to you for our next presenter.
Great. Thank you, John, so much for your time and for your presentation. So we will next move on to Suba with our wage and hour topic for the day. We appreciate Suba being a regular contributor and offering his expertise on these wage and hour issues. So Suba, go right ahead.
Thanks, Kristen. Good afternoon, everyone. Thanks for joining us for the webinar today. The topic today, the wage and hour topic that I picked, is the compensability of travel time. Figured it might be helpful to just kind of go through the rules on the various forms of travel and what is compensable and what isn't, because a lot of clients have questions in this area, and the rules aren't always completely intuitive. So thought it would be good to review. Next slide, please, Kathy. So ordinary commuting time, the general rule is that it's not compensable. And this is true regardless of whether an employee is required to report to a fixed location for work or different job sites each day. And a very extreme illustration of this was the Second Circuit decision from 2000, the Kavanaugh versus Grand Union Company decision. And basically the employee in that case, the plaintiff, was a refrigerator and utility mechanic for Grand Union grocery stores. He lived on Long Island, but he was responsible for about 50 stores across New York and Connecticut. Sometimes he was required to travel just commuting up to 4 hours each way from home to his first job site of the day and from his last job site back home. Grand Union didn't pay him for that commuting time. So Kavanaugh filed a lawsuit in federal court and Grand Union won. The Second Circuit decided in a 2-to-1 decision that all of that time, regardless of the distance and regardless of the length of the commute and the time it took to commute, all of it was excludable commuting time. It was not compensable because he was required to report to various job sites as part of his condition of employment. And he understood when he took the job that was part of his commuting time. The one dissenting judge said that it shouldn't be considered ordinary commuting time. These should all be considered separate, special one-day assignments, and all of his time should be compensable. And we'll get to this, the rule on special one-day assignments in a second. The one exception to this commuting time rule is emergency or call-out situations. Time spent traveling between home and work can be compensable if the employee is required to travel a substantial distance to perform the emergency work outside of regular work hours. That's the one exception. Next slide, please, Kathy. So this is the rule for travel on a special one-day assignment. So the dissenting judge in that Kavanaugh case said that all of Kavanaugh's commuting time really should be considered a special one-day assignment outside the geographical area. That time is compensable if there's no overnight stay required. So by way of an example, if an employee is employed in Syracuse, but has to travel to Buffalo for a special one-day assignment, the employee leaves home 6 a.m. and arrives back home at 7 p.m. All of that time from 6 a.m. to 7 p.m. is compensable, excluding whatever ordinary meal period the employee would get, as long as it's at least a 30-minute unpaid meal period. And this would be true regardless of whether the employee drives himself or herself or takes public transportation. If it's a one-day assignment, that distinction doesn't matter. So the one thing that can be excluded, let's say in this example, instead of driving, the employee took a train and the train left the Syracuse station at 6 a.m. and arrived back at the Syracuse station at 7 p.m. The time spent by the employee traveling from home to the train station and then back home from the train station is not compensable. But the time from the train station back to the train station is all compensable. Next slide, please, Kathy. Any travel time during the workday. So if an employee reports to a central reporting location and then travels to another job site to do work during the day, all of that travel is compensable. Some employees, as a condition of their job, have several work sites during the course of the day. Maybe they're a home health aide that travels from one client's home to another and sometimes services 4 or 5 people in the same day. All of that time, that travel time from one work site to another during the course of the day is compensable. Some clients ask the question, so the rate for the actual job duties is really high. Do I have to pay the same rate for the travel in between jobs that I have to pay for doing the regular job duties? And the answer to that is, unless you're limited by a collective bargaining agreement or a contract of some sort, there's no legal requirement to pay the same hourly rate for all different types of work. So you can pay travel time at a different rate than you would pay for regular job duties. A couple of warnings about that, though, is you need to make sure that you comply with minimum wage requirements. Your time records should specify how many hours are worked at each hourly rate. Because if an employee works overtime, all of these employees are non-exempt that we're talking about. So if an employee works overtime during the course of a work week, the overtime has to be computed at 1.5 times the blended hourly rate, or 1.5 times the higher hourly rate. If it's administratively easier to just pick the higher hourly rate and multiply that by 1.5 times, you can certainly do that, because it's obviously always permissible to pay an employee more than they're entitled to under the law. But what you can't do is that you can't just pay an overtime rate based on whatever rate was in effect during the overtime hours, because if some of that was travel time that's paid at a lower hourly rate, you're not going to be in compliance with the Fair Labor Standards Act. Next slide, please, Kathy. The last type of travel that's addressed in the regulations is out-of-town travel that requires an overnight stay. And basically what you have to look at first is, do the hours correspond to the employee's regular workday? So if an employee regularly works 9 a.m. to 5 p.m. Monday through Friday, all travel time during those hours are going to be compensable, regardless of whether it occurs on a Monday through Friday or on a Saturday or Sunday. So out-of-town travel between 9 a.m. and 5 p.m. is going to be compensable even on a Saturday or Sunday. Next slide, please, Kathy. If it's outside of the regular work hours, then we have a difference in compensability if the employee drives versus if the employee takes some form of public transportation. So if it's outside the employee's regular work hours, it's always compensable if the employee drives himself or herself to the work site. It's not compensable if the employee is just a passenger on an airplane, train, or car. So that can lead to some paradoxical results under the regulations. So for instance, if you have two non-exempt employees who are required to travel to the same destination outside of their regular work hours, one of them drives, one of them's a passenger, technically, under the regulations, the person driving gets paid. The person who's the passenger doesn't get paid. So some of these issues that you'll probably have to address in your own policies to avoid those sorts of inequities. But that's, in the absence of a policy, there's nothing legally impermissible about paying the employee who drives and not paying the employee who's the passenger. You're going to have a very discontent employee on your hands, but that's something that should be addressed through your employee relations policies. So by way of an example, if an employee regularly works in New York City from 9 a.m. to 5 p.m. Monday through Friday, the employee is required to fly from New York City to Raleigh on an 8 a.m. flight on Wednesday and arrives in Raleigh at 10 o'clock a.m. The time from 8 a.m. to 9 a.m. is not compensable, and the time from 9 a.m. to 10 a.m. is compensable. And remember that all of this assumes that the employee isn't actually performing job duties while they're on the plane. So, if they're on the plane and they need to do something to prepare for the meeting, so they're reviewing notes, putting together a presentation, whatever it is that they're doing on the plane, if those are otherwise compensable job duties, the fact that it's occurring while traveling doesn't all of a sudden make them excludable from compensation. So bear that in mind as well. If any of you have any questions about travel time, please feel free to reach out to me separately or put a question in the Q&A, and I'll do my best to get back to you. I'm going to send it back to you, Kristen. Thanks.
Thanks, Suba. Very helpful. These rules are not always intuitive, as we see. There's a few questions if you want to take a look at those. I did want to mention, because I accidentally clicked to the answer live button on one of them, which is whether this is New York State or federal law, and I'll let you answer that.
This is federal, but New York State has adopted the same travel time rules as the Fair Labor Standards Act rules.
Great. Thank you so much, Suba. All right, moving on to our next topic. We have Jackson Soames, an associate in our Rochester office, to talk about a brand new Supreme Court case. So tell us about it, Jackson.
Thank you, Kristen. And the case I'm going to talk about, the name of the case was Perez versus Sturgis Public Schools. It's a public school district out of Michigan. And the case revolved around schools and school districts and disagreements with student disabilities. And ultimately, this is likely to increase federal litigation involving students with disabilities and disputes with these school districts. Now, the issue before the court was whether a student with disabilities may bring a claim for monetary damages against the school district under the Americans with Disabilities Act, the ADA, and whether they're able to do that without first exhausting the administrative procedures that are generally outlined by the Individuals with Disabilities Education Act. So if we could go to the next slide, Kathy. So first, I wanted to provide a broad and general overview of these two statutes that were, or these two acts, these two federal laws that are addressed in the Supreme Court decision. So first, we have the Individuals with Disabilities in Education Act. And this law generally guarantees that students with a disability will be provided a free, appropriate public education, and that education will be specifically tailored to the individual's needs. Now, if a student with disabilities or their family, if they think that this free, appropriate public education is not being provided, then the IDEA has administrative procedures that the student or the family must go through, as opposed to just bringing a claim directly in federal court. And what it generally requires is a complaint before an administrative agency, and then a hearing will be held. And if the student or the family disagree with the outcome of that hearing, then they have to appeal that decision to the state education agency. So in New York, it would be NYSA, the New York State Education Department. Now, in contrast, the Americans with Disabilities Act is a much broader law, and it generally prohibits discrimination against individuals with disabilities. And this will include in context areas such as employment, transportation, public accommodations, access to government programs, et cetera. Now, as you can see, the Individuals with Disabilities and Education Act is much more narrow and deals specifically with addressing issues when a student is denied a free and appropriate public education. We can go to the next slide. Now, here are some of the background and factual issues in this case. So Perez, he was a student with a disability. As I mentioned, he was a deaf student, and he attended Michigan's Sturgis Public Schools for 11 years. As his school career was wrapping up, right before graduation, he was told that he was actually not eligible to receive a high school diploma. And this came as a surprise, not only to him, but to his parents as well. And so him and his parents, they filed an administrative complaint against the school district, alleging that the school district violated the Individuals with Disabilities Education Act, that they denied him this free and appropriate public education. So they're going through the administrative steps outlined in the IDEA. But before the hearing took place, the parties came to a settlement, and they agreed, and the school district agreed to give Perez basically all that he had requested, including funding so that Perez may continue his education at a private institution that provided schooling for deaf people. But after that settlement was agreed upon by the parties, Perez then filed a federal lawsuit seeking compensatory damages or money. And they brought that lawsuit in federal court under the Americans with Disabilities Act. We can go to the next slide. At the heart of this decision was one specific section of the IDEA, which says that nothing under the IDEA shall be construed to constrict or limit the rights and procedures and remedies available under other federal laws, including the ADA, except that before they can file a civil action in federal court under laws such as the ADA, and seeking relief that is also available under the IDEA, first the student has to exhaust all of the administrative procedures outlined in the IDEA. And if we go to the next slide. And what the district said is that the harm that Perez and his family is trying to address here can be remedied by the IDEA, and therefore they must have to go through these administrative procedures. They must file the administrative complaint, have the hearing, and if necessary, have the appeal with the state education agency. And the district court that first heard this argument, they agreed with the school district, they agreed with Sturgis Public Schools, and the Sixth Circuit also agreed with the school district. But meanwhile, Perez, his argument was that I'm seeking money damages here, and money damages are not an available remedy under the IDEA, and therefore I should not be barred from filing this federal lawsuit without first going through the IDEA procedures. And if we go to the next slide. And the Supreme Court ultimately agreed with Perez, saying that this lawsuit in the federal court may move forward, that he doesn't have to go through the administrative procedures outlined in the IDEA because he's seeking money damages. And we can go to the next slide. Now, the interesting part here is, what will be the impact of this decision? And ultimately, this is going to open up potential liability for schools. A quick thing that I want to note is that this holding applies to all states, even though the facts that happened in this case only occurred in Michigan. This holding will apply to all states. And ultimately, this will probably encourage parents to file claims seeking money damages in special education disputes. And where a lot of this action will likely take place is in the settlement negotiations, and parents and students with disabilities will likely, feel that they can seek money damages in settlement negotiations for IDEA disputes. And that wraps it up for me.
Okay, thanks so much, Jackson. Appreciate it. Finally, last but not least, as they say, Dory Bailey in our business department here is going to talk to us a bit about FDIC, something that we never really thought about probably too frequently until the news the past few weeks, where it's been an important topic of consideration by many people as they've been watching what's been happening out there. So if you could talk us through this, that'd be great, Dory.
Sure. Thank you so much, Kristen. So yes, I'll be speaking about the recent bank failures and some of the basics of FDIC insurance. And of course, the recent bank failures have caused significant concerns among many parties in the industry regarding financial institutions. So basically, things started off with Silvergate Bank. And Silvergate Bank announced on March 8th that it was going to be undergoing voluntary liquidation due to issues related to its involvement with the cryptocurrency industry. Then Silicon Valley Bank was closed on March 10th by the California Department of Financial Protection and Innovation, and the FDIC was appointed as receiver of the bank. And Silicon Valley Bank was the second largest bank failure in US history, so a very large failure. As of December 31st, 2022, Silicon Valley Bank had approximately $209 billion in total assets, so very large failure. And the failure basically stemmed from a run on the bank in which depositors withdrew over $42 billion in a single day, causing the failure of the bank. Now, as receiver of the failed institution, the FDIC transferred all the deposits, including the insured deposits and the uninsured deposits, as well as substantially all the assets of Silicon Valley Bank to Silicon Valley Bridge Bank. And Silicon Valley Bridge Bank was operated by the FDIC. And so what basically happened was all the customers of Silicon Valley Bank automatically became customers of Silicon Valley Bridge Bank. and depositors continued to have access to all of their deposits. They were able to write checks. They were able to make withdrawals by ATM, by debit card. Any official checks of Silicon Valley Bank continued to clear. They're all honored. Any direct deposits, such as paychecks into Silicon Valley Bank, continued to be processed as normal. Any loans, any borrowers that had loans with Silicon Valley Bank, the terms remained unchanged and people could continue to make their loan payments. And then 7 days after the failure of Silicon Valley Bank, First Citizens Bank acquired Silicon Valley Bridge Bank, the new bank, and they acquired that bank and they now own Silicon Valley Bridge Bank. So basically that failure was resolved through the acquisition by First Citizens Bank. Then we have Signature Bank, and Signature Bank was closed on March 12th by the New York State Department of Financial Services, and the FDIC was appointed as receiver. This was just 2 days after the failure of Silicon Valley Bank. And Signature Bank was the largest bank, the third largest bank failure in US history. Signature Bank had total assets of $110 billion. So again, the third largest bank failure in US history. And in this case, depositors withdrew more than $10 billion in deposits on a single day, leading to this bank's failure. And in this case, the FDIC transferred all the deposits, including the insured deposits and the uninsured deposits, and substantially all the assets of Signature Bank to Signature Bridge Bank, which was operated by the FDIC. And depositors and borrowers automatically became customers of Signature Bridge Bank, and depositors continued to have access to their deposits. They were able to write checks or make withdrawals, and loans remained unchanged. And then 8 days after Signature Bank failed, March 20th, Flagstar Bank acquired Signature Bridge Bank. So that failure was also resolved through an acquisition. So I just wanted to take a few minutes to discuss, the terms that I've been talking about, sort of this bridge bank concept. So a bridge bank is basically a national bank that is created and operated by the FDIC to bridge the gap between the time when a bank fails and the time it takes the FDIC to stabilize the bank and market it to another financial institution. Now, normally the FDIC will transfer only the insured accounts and certain assets to this bridge bank. But as we've discussed, in the case of both Silicon Valley Bank, the FDIC transferred both the insured deposits and the uninsured deposits to Silicon Valley Bridge Bank. And about 88% of the deposits of Silicon Valley Bank were actually uninsured. And all of those deposits ended up being protected by the FDIC. Similarly, in the case of Signature Bank, the FDIC transferred the insured deposits as well as the uninsured deposits to Signature Bridge Bank. And about 90% of the deposits of Signature Bank were uninsured. And again, all those deposits were protected. Now, this transfer of all the deposits, including the uninsured deposits to the respective bridge banks of these two failed institutions, this was all accomplished under what's called a systemic risk exception. So the FDIC is required to explore all options and find the least costly method to resolve a bank failure. And the Federal Deposit Insurance Act also provides for its systemic risk determination. So if the Secretary of the Treasury determines that the FDIC's compliance with the required least cost resolution of an insured depository institution would have serious adverse effects on economic conditions or financial stability, then the FDIC may take other action or provide some other type of assistance in order to mitigate those adverse effects. So in the case of both Silicon Valley Bank and Signature Bank, the Secretary of the Treasury approved this systemic risk exception. And under the exception, all depositors of the financial institution basically were made whole. They were paid out for their insured deposits as well as all their uninsured deposits. And interestingly, many people talk about, well, this is some type of bailout and is this good for taxpayers? But actually, under the law, the taxpayers are not required to absorb any losses as a result of this systemic risk exception. So if there's any losses to the Deposit Insurance Fund due to paying out these uninsured deposits, then those losses are actually recovered by a special assessment that the FDIC charges to all the rest of the banks. So it doesn't go back to the taxpayers. Now, one thing that I think is important to note is that the systemic risk exception is only really used by the FDIC on a case-by-case basis. So the fact that the Secretary of the Treasury approved a systemic risk exception in the case of both Silicon Valley Bank and Signature Bank does not mean that if another bank fails, the Secretary will automatically approve a systemic risk exception for that bank's uninsured depositors and cover all those uninsured deposits. It's really a case-by-case decision that the FDIC works on with the Secretary of the Treasury. So it's really hard to predict and know what they will do with any particular bank failure. And so now I just wanted to just briefly talk about some of the basics of FDIC insurance. Now, of course, the FDIC insures deposits of banks, and currently the insurance level is $250,000. And basically, this federal deposit insurance really helps to stabilize the financial system. It provides sort of a guarantee to depositors that their money will be repaid regardless of what happens to their bank up to a certain amount, if their bank were to fail. And basically under federal law, all nationally chartered banks, as well as state chartered banks that are members of the Federal Reserve System, all are required by law to be insured by the FDIC. Those state chartered banks that are not members of the Federal Reserve, they're still required under state law to be insured by the FDIC. So whether you're state chartered, nationally chartered, whatever type of bank it is that you might have your money with, they're all required to be insured by the FDIC under either state or federal law. Also, the National Credit Union Administration insures credit unions up to $250,000 as well. So the same insurance limit. And basically the way it works is the $250,000, the current insurance coverage is per depositor, per depository institution in each category of ownership. So some of the different categories of ownership are single accounts, which are basically just accounts owned by one person, joint accounts, which are accounts owned by two or more people, corporate accounts, partnership accounts, certain retirement accounts, such as IRAs, trust accounts, such as in-trust for accounts, payable on death accounts. And basically the way it works, just a few examples, is let's say there's an individual and they have two single accounts, meaning they're just one person is on that account at the same depository institution. So let's say John Smith has a checking account as well as a savings account at the same depository institution, the same bank. Each account has $250,000 in that account. So he has a total of $500,000 at that single bank in those two single accounts. That person would only be covered by deposit insurance up to $250,000. The second $250,000 in the other account would be uninsured and would be potentially at risk. However, if that same individual has two different banks and has a checking account at Bank A and a savings account at Bank B, and there's still two single accounts just with John Smith's name on them, but there are two different banks, then the $250,000 at Bank A and the $250,000 at Bank B both are fully insured. And so John Smith would have $500,000 covered by the FDIC if both of those banks were to fail. Last example, let's say an individual has a single account with $250,000 at Bank A, and then has a joint account also with Bank A, with the same bank, but it's joint with another person. So we have John Smith and Jane Smith, a joint account at the same bank. Each of those two accounts have $250,000 in them, and both of those accounts, even though they're both at the same bank, would be fully covered. So $500,000 would be covered for a single account and a joint account, both at the same bank. So that's basically it. If you have any questions, please feel free to give me a call, send me an email. I'll be happy to answer any questions you might have. Thank you. I'll turn it back to Kristen.
Thank you, Dory. And in fact, you did answer one of the questions that one of our attendees had put in the Q&A section. So thanks for doing that without even realizing it. But that wraps up for today. We're right at 12:45, perfect timing. I want to thank our presenters and our attendees. On our slide here are our presenters' contact information in case you have follow-up questions. We always appreciate you attending our webinar on a weekly basis, and look forward to seeing all of you every other week. as I continue with these hosting duties. So looking forward to it, and thanks again. Have a great day.